The judicial review system, established by the justices through constitutional interpretations, is to safeguard the constitutional system and to protect the fundamental rights of people. As of today, the number of the constitutional interpretations issued by the justices has exceeded 760. Every one of these interpretations was a step toward the summit, where the constitutional structure of free democracy stands. How we pass on the torch, inspire the generations to come, and surpass the existing system is part of the story we will tell about the past 70 years.
The justices' duties are to interpret the Constitution, issue uniform interpretations of statutes and regulations, form a constitutional court, declare the dissolution of any political party violating the Constitution, and sit as judges in impeachments of the President and the Vice President. The Constitutional Interpretation Procedure Act, amended in 1993, stipulates that the Constitutional Court may apply to cases of constitutional interpretations to hold oral arguments if necessary.
There have been 10 cases in which the justices held oral arguments in the form of a constitutional court. The first one took place during the 5th term, JY Interpretation number 419, on the issue of whether the Vice President may concurrently hold the office of Premier of the Executive Yuan. There was also an oral argument on the constitutionality of the Organic Act of the 319 Shooting Truth Investigation Special Committee. And we also had JY Interpretation number 603 on the collection of fingerprints as a condition of national ID issuance, in which the justices found the mandatory collection of fingerprints to be an infringement of privacy.
In JY Interpretation number 499 on the Third National Assembly's resolution employing a secret ballot to pass additional articles of the Constitution, seeking to extend its own term, the justices declared it invalid immediately and confirmed the limitation on constitutional amendments.
The justices in JY Interpretation number 499 took the stance that there is limitation on constitutional amendments. The parts of essential importance in the Constitution are untouchable, and the fundamental norms of procedure inviolable. Even when a constitutional amendment is passed, the justices may still review such an amendment and consider it to be unconstitutional. So, in JY Interpretation number 499, not only was the procedure adopted considered unconstitutional, the contents of the amendment were also considered unconstitutional, which prompted the amendment to be rendered invalid immediately.
In JY Interpretation number 445, the Assembly and Parade Act, adopting prior censorship on people's political speech, was declared unconstitutional.
This is an interpretation securing people's freedom of assembly and parade, and also a symbolic interpretation protecting fundamental rights. The justices regarded the freedom of expression as equally important as personal liberty and believed that, should the freedom of expression not be protected fully, a free democracy would not fully develop.
JY Interpretation number 530 stated that the Organic Act of the Judicial Yuan and related regulations should be revised to be consistent with the original purpose of the Constitution, considering the Judicial Yuan as the highest judicial adjudicative organ.
This case involved the position of the Judicial Yuan. The intent of the Constitution or of the farmers is very clear. The Judicial Yuan is an adjudicative institution.
The Judicial Yuan now urges the revision of the Constitutional Interpretation Procedure Act and judicial reforms, such as to establish a pyramidal system of litigation for an adjudicative Judicial Yuan and to embody intentions of JY Interpretation number 530. Whether preserving the constitutional system or protecting human rights, the justices' scope of constitutional interpretation has been broadened to embody the framers' intent.
A very important part of the justices' duty of constitutional interpretation is the protection of human rights. I recall when I joined the office on February 1st, 1999, our first case of interpretation was JY Interpretation number 477. We had to sort out the compensation for people's loss or injury during the period of martial law. After the martial law was lifted in July 1987, a statute was passed by the Legislative Yuan to provide the victims in that period of time with compensation from the state. But the stipulations in that statute only allowed those who had been exonerated with a final court decision to claim the compensation for the wrongful imprisonment during that period of time. However, we knew that, as a matter of fact, during that period some people were first detained for unknown reasons, and later released for unknown reasons with no court decision of exoneration in hand whatsoever. That is why JY Interpretation number 477 was to amend the statute, so as to include the people left out by it. JY Interpretation number 653 was about the detained defendants who were subject to solitary confinement in the detention center, probably for violating some internal rules. According to the rules then, these detained defendants could only file internal complaints, but not administrative appeals. JY Interpretation number 653 thus indicated that this is a violation of their right to judicial remedy and declared it to be unconstitutional. It was then followed by JY Interpretation number 654, which was about the rights of detained defendants. When an attorney visited a detained defendant, based on the rules of that time, the whole visit was required to be video and sound recorded. Furthermore, is that the conversation between the defendant and the attorney could be the evidence to convict such a defendant eventually. This, in the aspect of litigation to a detained defendant, was indeed not very fair. So we then considered the rule that a visit must be sound recorded under whatever circumstances to be a violation of the proportionality principle, and the rule that the recording was admissible in court to convict such a defendant to be a violation of the right to judicial remedy. If we consider the Justice's interpretations as a journey, it is a journey in which we keep extending the reach of the rights guaranteed by the Constitution to the oppressed and to the excluded.
In the past decade, the Justice's oral arguments are open for the public to attend and live-streamed online, presenting its whole process in the Constitutional Court. Meanwhile, many symbolic interpretations were issued.
Regarding JY Interpretation number 689, it responded to the facts that some celebrities in our society, or some newsworthy figures, are often stalked or followed by reporters, which can be annoying. They then followed the legal procedure to petition for an interpretation from the justices. The justices indicated that the Social Order Maintenance Act, in order to protect people's freedom from injury, from bodily and mental harm, the freedom of movement, privacy, the freedom in the private domain, the freedom from unreasonable intrusion in the public space, as well as the data autonomy, the autonomy over personal information. In order to protect these rights, imposes restrictions on acts of unreasonable stalking and acts of trailing by reporters, which did not violate the stipulation and principle of the freedom of the press in the Constitution, and thus declared the Social Order Maintenance Act to be constitutional. After this interpretation, the restriction applies not only to the reporters affiliated with professional news agencies, but also to the so-called citizen journalists with no affiliation. And therefore our norms of journalism under the freedom of the press became more reasonable. In JY Interpretation number 711, the Justices, regarding a provision of the Pharmacists Act, which says, a pharmacist may only practice at one single place, thereby pointed out the Pharmacists Act limits a pharmacist to only practice at one single place, with no reasonable exception permitted, such as an emergency. or to practice outside the office for important public interests. This constitutes an undue burden on pharmacists' professional practice, and therefore contradicts the proportionality principle of the Constitution, and contradicts the spirit of the Constitution to protect the right to work. So, the justices declared this provision of the Pharmacists Act to be unconstitutional. This interpretation further resulted in the subsequent revision of the Pharmacists Act.
In the past, according to the Criminal Procedure Code, defendants and their counsels had no access to dossier information during detention hearings at the investigatory stage. Defendants had to face the most serious pretrial compulsory measure, the pretrial detention, with limited and asymmetric information. Questioning its procedural justice in this respect, the petitioner petitioned for an interpretation from the justices.
JY Interpretation Number 737 was issued to resolve the problem that, when a motion was filed to detain the defendant, the detainee was deprived of his personal liberty in the same way as serving a sentence in jail. Of the motions to detain the defendant at the investigatory stage, many were filed for unclear reasons, but were still granted and the defendant detained. For this, the justices suggested, based on the personal liberty and the right to judicial remedy protected by the Constitution, that at the detention hearings, it should be required for the prosecutor to disclose the reasons for the motion for detention, so as to allow the criminal suspect or his counsel to know the reasons for the motion for detention. Otherwise, he cannot possibly defend himself. This requirement does not stop at the reasons for the motion for detention. If there is no indication of destruction, forgery, or alteration of evidence, conspiracy with a co-offender or witness, perjury, or other situations which would jeopardize the purpose of criminal investigations, or the lives or the bodies of other people, not only must the reasons be disclosed, but also the relevant evidence be made available for the criminal suspect and his counsel to know and allow him to fully exercise his right of defense. Only this would comply with the due process of law required by the Constitution. This interpretation led to the revision of the Criminal Procedure Code in 2017.
The justices also issued interpretations on cases about the Civil Code, the freedom of same-sex marriage left unprotected by the Civil Code receiving the most attention in recent years.
The justices were also aware that this petition would have a long and significant impact on the society. So we therefore opened the Constitutional Court and had the plaintiffs, who were the petitioners, express their opinions. We also invited the experts and scholars to express their opinions from different perspectives. In the end, according to the interpretation finally approved by the majority of the justices, it was found that the current Civil Code, specifically the provisions in the chapter of marriage under the part of relatives, does not allow same-sex marriage to take place. And these kind of provisions were considered as an infringement on the freedom of marriage of homosexual people and their right to equality as protected by the Constitution. And therefore, it was declared to be unconstitutional. The interpretation required the related authorities within 2 years to revise the code.
JY Interpretation Number 748 has received considerable attention in the international media and made our country the first in Asia guaranteed by the Constitution the equal rights of same-sex marriage. Some Western countries also passed relevant laws in the same year.
Regarding the censorship and restrictions on freedom of speech, generally censorship only reviews an instance of speech after its delivery. If the state seeks to impose prior restraint on freedom of speech, only under exceptional circumstances would prior censorship be permitted. Advertising is surely included as part of the protected speech. The justices in JY Interpretation number 744 held that the use of prior censorship on speech must be for the prevention of direct, immediate, or irreversible damage to people's lives, bodies, or health, or to serve a public interest of special importance. Because advertisement is to persuade the consumers to make the purchase, yet it has still not gone so far as to cause direct use of the makeup products. So, the justices considered the use of prior censorship was to prevent damage not as serious as irreversible damage to people's bodies or health, and thus declared it to be unconstitutional. As to the rights of prison inmates, in the past, it was usually based on the doctrine of special relationship of subordination to exclude prison inmates from the protection of fundamental rights during their sentence. One of the most important contributions the justices made by issuing JY Interpretations numbers 755 and 756 was to confirm that prison inmates also have protected fundamental rights, including the freedom of secrecy of correspondence and their freedom of expression. As such, if the restrictions imposed on their rights by the state exceed the necessary extent, and if the inmate wants to challenge such restrictions, he may file a complaint. If after the complaint he thinks that he has not received a proper remedy, he may further seek remedy from the court. This is a transcendent change.
We expect the sunshine to break the darkness in prisons and to turn a new page in the protection of inmates' rights in our country. The justices have been visiting and interacting with foreign jurists for many years. We therefore understand the latest developments of the judiciary in different countries. Our justices also gain international visibility. In September 2014, Albie Sachs, former justice of the South African Constitutional Court, visited us and shared his experience in drafting a new constitution for South Africa and the Constitutional Court's forward-looking decisions for protecting human rights. President Shu Jong-lee was invited by the President of the Constitutional Court of Lithuania to attend the 4th Congress of the World Conference on Constitutional Justice. Between 2017 and 2018, Professor Hanna Kuba of the Heidelberg University, Professor Stefan Korioth of the Ludwig Maximilian University of Munich, and Professor Christian Stark of the University of Göttingen successfully visited the Judicial Yuan. These esteemed scholars of public law in Germany gave seminars on the experience of constitutional adjudication in Germany and the relationship between international human rights treaties and the German Constitution. The justices' missions entrusted by the Constitution are interpreting the Constitution and protecting the fundamental rights of individuals. Reform of constitutional interpretation needs to reflect the public opinion, respond to their wishes, and keep up with the times. It's been 25 years since the Constitutional Interpretation Procedure Act, the legal basis of the justices' constitutional interpretation, came into force in 1993. In many respects, it's necessary to review and adjust the current law and reform the system.
The reform of the current system of the justices' constitutional interpretation is a very important part of judicial reform policy, pushed for by the Judicial Yuan. We are now preparing to undertake significant revisions to the current Constitutional Interpretation Procedure Act and to rename it as the Constitutional Litigation Law.
The draft includes comprehensive judicialization of the method of constitutional interpretation. The justices form a constitutional court to review cases and present results as a decision. Make the processes public and transparent. Lower the votes threshold required for the Constitutional Court to improve the justices' efficiency in reviewing the cases. Establish the system of constitutional adjudication, and extend the scope of the cases to the review of final court decisions.
The infringement of people's fundamental rights is sometimes caused by an unconstitutional statute and is sometimes caused by the judge's application of statutes. In the past, we only allowed the people to petition for an interpretation for an unconstitutional statute. Now, our current new change is to allow the people to challenge the unconstitutional application of statutes by a judge, which is an unconstitutional court decision. For this kind of case, people may petition for an interpretation from the justices as well. After all, if a petition for interpretation is allowed for an unconstitutional statute, considering that a judge's adjudication is also an exercise of public authority, this violation of Constitution should also be reviewed by the justices. In this way, the protection of human rights offered by our system of judicial review can be more comprehensive.
Lastly, is to stipulate the rules of adjudication for impeaching the President and the Vice President to complete the system of law.
The system of the justices' constitutional interpretation will move toward the direction of judicialization, which is the direction of courtroomization. We expect that in the future, with a whole new progressive perspective, we will build a new rule of law to have greater impact on the preservation of the constitutional structure of a free democracy and the protection of the fundamental rights of people.
The Constitution protects our fundamental rights as the foundation of the rule of law. It realizes democracy and human rights and enables us to live without worry. Over the past 70 years, the justices of the Judicial Yuan have safeguarded the Constitution. In the future, the judicial reform needs to be supervised by all people to make the system of constitutional interpretation timeless and enduring.